What led to today's move by the federal government to consider to close a legal loophole? In 2018, a Calgary man broke into a home and violently attacked the occupant. He was naked, drunk, and high on magic mushrooms, and his case went all the way to the Supreme Court of Canada. The top court upheld his acquittal, effectively ruling that an individual accused of a violent offense can use the defense of self-induced extreme intoxication. Today, the Canadian government introduced new legislation aimed at closing that legal gap. David Lametti is Minister of Justice and Attorney General of Canada. Minister Lametti, thanks for coming in.
My pleasure. Good to be back.
So let's start with the substance of this. The Supreme Court found the old law constitutional, effectively allowing people accused of violent crimes to use self-induced extreme intoxication as a defense. How does this new bill change that?
Well, first of all, let me just say that it's only in a very, very small fraction of cases where that defense is possible. It is, and I need to repeat this to Canadians, is that getting drunk, getting high is not a defense to sexual assault according to our criminal law principles and the common law principles that are embedded in our criminal law. In the vast, vast majority of cases, it's simply not a defense. In this particular case, where the previous law, when you became intoxicated to a point you reached automatism, so you were no longer in a state where you could control yourself or your actions. They felt that the provision was too wide, and it didn't distinguish between people who negligently reached that state and people who might have innocently reached that state. So what we've done here, and following what the Supreme Court told us we might do in the case, is we've criminalized the situations. Again, the majority, even of that minority of cases, the majority of those cases where a person was really criminally negligent in getting high, or in usually high on drugs or mixed with alcohol, to reach that state where they lose that control.
Right, so let's look at the example of the case that caused all of this. This is the Calgary man who assaulted violently a Calgary homeowner, was drunk and high on magic mushrooms. And that was ruled that this person was not criminally responsible. So how does what you're proposing today change a case like that?
Well, if the situation is such that the person ought to reasonably have known, or it was reasonably predictable that one would have lost control by ingesting magic mushrooms or whatever they are, then they're still going to be found liable of the offense, the actual offense, sexual assault or whatever it is, assault, for example. If, on the other hand, the person, say, was taking prescription medication for the first time and had a reaction that was completely unpredicted, that person would be able to avail themselves of the defense.
Okay, so it really comes down to just foresight and whether you could judge before you took these acts whether or not you're exposing yourself to an extreme intoxication situation. So if I'm given a prescription by my doctor and I don't know how it's going to affect me and I have a bad consequence, then that avenue is open to me. But if I decide to get high on recreational drugs and end up in a zombie state and commit a crime, forget it. I'm going to be tried as if I was mentally responsible and alert.
Well, that's right. You need to reach a standard of criminal negligence, which is familiar to our law, which judges and lawyers and other participants are familiar with. And so if you were negligent in reaching that state for whatever reason, I'm not going to speculate on all the possibilities, but that's basically it.
So the court struck down the last one as unconstitutional. What steps have you taken to ensure that this one, this fix to the loophole, will survive potential charter challenges and court challenges? Well,
first of all, we think we're on track with the options the court gave us. But as soon as the decision came down 5 weeks ago today, we began our work right away. We spoke with stakeholders across Canada. We spoke with legal experts across Canada. We began speaking with our counterparts. We received letters from some of my provincial counterparts, territorial counterparts, saying, please act on this. And look, a number of people have thought for a number of years that the previous position, previous article going all the way back to the Davio case, which caused it 20-odd years ago, was susceptible to being challenged.
Right.
So this wasn't unknown, and when we pleaded the case and we lost. We were ready to move, and we've moved. We've moved with lightning speed, and I think we've come up with something that is quite reasonable and quite acceptable.
Okay, so, right off the top in your first answer, you mentioned sexual assault. And at the news conference today, there's a lot of talk about sexual assault and gender-based violence, but sort of none of the cases that fed into the Supreme Court decision, which led to today, involve sexual assault, right? So why such an acute focus on that when this is not what these cases were about that led to this decision?
Well, in part because of the misinformation that came as a result of that Supreme Court decision.
Misinformation or misunderstanding?
Both. Both. Misunderstanding leading to misinformation is probably the more accurate way to put it. People are out there tweeting saying, well, now you've got a ticket to, you've got a ticket to being acquitted if you have a few drinks and you sexually assault someone. Marcia Ian today in the press conference mentioned the example of her daughter coming home and saying, what's this about? And so there was a real fear out there, like hundreds of thousands of hits on these sites, and in one case a couple of million hits. And again, it's wrong. You don't have that defense in those circumstances in any event, but this decision opened the door to that. So of course what we're doing today applies to more than just sexual assault. It applies to assault, it applies to homicide, any general intent offense in the criminal code. So we're doing this, I hope, to pass the test of time, but also to be consistent with our charter.
Right. So there's an acute anxiety amongst women in particular
Absolutely
about this,
right.
and so
Absolutely
it's
right.
Whether
That's
it was right or wrong, you felt the need to address it.
We were explicitly addressing that today.
Right. So you say going into this Supreme Court argument that you thought you might lose this because you knew there were potential problems. Are there other laws on the book where you have this same level of concern about that you might need to review and reconsider based on the lessons learned from this case?
I think this was probably the most acute. In fact, the argument that we made at the Supreme Court, it was effectively the argument, or this inconsistent with the law that we've now proposed, which is we ought to have interpreted the previous provision this way. Now we're going to do it formally. But they're rare. These cases are rare. A dozen cases since the inception of the law. So this is very, very rare. And again, I want to underscore that to Canadians. This is a very rare set of circumstances. Automatism is a very rare condition. And so people need not worry. The criminal justice system is functioning well. Severe crimes get punished appropriately, and we're making sure that we're consistent with that.
It's rare, but it was important enough, obviously, for the Supreme Court to hear it, and we do have cases now where people are free because this was struck down. You've introduced this legislation, and you've spoken to the anxiety that people felt about the misunderstanding of what this meant. The parliamentary calendar is getting short, right? So here we are tabling this, or seeing this tabled in June. I mean, how quickly can this become the law of the land? Because Parliament's probably done next week.
We hope very quickly. We have kept our parliamentary colleagues in touch, in the loop on this, to the extent that parliamentary privilege allowed us to do that. So both with respect to the House and my critics in the House, as well as in the Senate, we have let people know that something was coming and that this was something they could probably live with. And so we're hoping we can move pretty quickly. There is a real consensus, I think, in Canadian society from a variety of different groups. You saw some of them today, who think this was a good way to move, this was the right way to move, and that it ought to be done quickly.
There's broad support, but it's Friday, and the House may rise on Tuesday. I mean, will you seek unanimous consent? Have you talked to the Conservatives, New Democrats, the Greens, and the Bloc about that? Is that a possibility to get it done?
I will do my best.
Okay, but there have been no conversations to this point? I know it's only been a couple hours since you announced it.
There have been conversations. I will do my best.
Okay, and any sense you get resistance?
So far, I think there's been a pretty good acknowledgement that this is a good way forward, and that this is something we can work with.
Okay, David Lametti, thanks for coming in.
Thank you.
Hi, I'm Vashi Capellos, host of Power in Politics. See more of our show by subscribing to the CBC News channel or click the link for another video.